Great. Hi, everyone. So for our, last but not least, our final part of programming for today, well, we're going to be first hearing from Norm Letalik and then Aldo Chircop, but I will just do a brief introduction for Norm. So I'd like to introduce Norm Letalik. Thank you for being here with us today. And we are very proud to count him among Dalhousie Law's alumni, both as a former student and professor. So following his years here in Halifax, where he was a research associate, an assistant director of the Dalhousie Ocean Studies program, he became a partner in the Toronto office of Bordner, Ladner, Gervais, where he practiced for over 25 years as a litigator. Following his retirement from BLG, he served variously as general counsel, corporate secretary, corporate director, chief privacy and compliance officer, and vice president general counsel at a myriad of global automotive companies. But enough from me. Without further ado, Norm.
Thanks, Sarah. First of all, thanks for inviting me. My part is very easy. It's talking about the good old days and how much fun I and a number of other people in this room had at Dalhousie back in the days when MELP first started, when it was, brought forward as an institution that had traction not only in the law school, but across the university. That doesn't happen by chance. A lot of work has to be done in order to make sure that that happens. But just to give you a little bit of context, MELP, obviously, since this is the 50th anniversary, started in '75. I wasn't able to take advantage of it until 1977, when I arrived as a law student, having done something incredibly foolish by going to McGill for my first year of law, quickly realizing the error of my ways, and then learned how to go from darkness into light when I arrived here at Dal in September of 1977. There were only 3 of us that were transfer students, and for those of you who have been first-year law students, you know that's where all of the real, let's call it almost trench closeness develops, almost to the point where the different sections have, oh, but you're a section B, I only talk to section A's. So we were a bit outsiders, and just by serendipity, one of the other people that arrived at that time was Ted McDormand, a name that those of you who are interested in this field will know extremely well. Ted and one other student from UMB, Mike McDonald, for those of you, some of you may not know him, but he did okay in life. He wound up being the Chief Justice of Nova Scotia. So the 3 of us arrived, and Ted and I both had a very strong interest in international law. And back in those days, a building that doesn't exist anymore, actually I think it was just a little bit over there on Henry Street, is where both Doug Johnston and Edgar Gold hung their hats. And we introduced ourselves to them, and then in very, very quick order, we not only learned which courses they had available, but also the exciting things that were starting to happen here at Dalhousie at that time. Just totally fortuitously, we arrived at the right time. Now, to set the stage a little bit more, I have to go back quite a ways, and that's back to 1963. And you say, why? I mean, MELP, that's well in advance of MELP, and that's because that's when Henry Hicks, who became Senator Henry Hicks, became president of Dalhousie University. For those of you, most everybody knows that the head administration building is now called the Henry Hicks building, and that's for good reason. He was an amazing guy. I got to meet him a couple of times, even managed to have lunch with him a few times. And he was just a whirlwind of a person. He had a science undergrad, then came to Dalhousie to kind of buff up his credentials a little bit. from having done the science degree at Mount A, and then did the right thing and managed to get a Rhodes Scholarship. So he went off to the UK, got a law degree, then came back. Then the war started. He was one of the pioneers in using radar to help defend Britain at that time. And then when he came back, he immediately went into politics. So he got elected into the provincial legislature, and within a few years, he was the Premier of Nova Scotia. So from 54 through 56, he was the Premier. And just prior to that, his portfolio before becoming the Premier, he was the first ever Minister of Education in Nova Scotia history. So that's tremendous background. He wasn't as keen on being in the opposition, so after a few years of that, he migrated to Dalhousie, first as the Dean of Arts and Sciences, and then for a very short period, the Vice President, and then he became President. And he did an enormously good job of persuading people that Dal, which in the old days was known as the Little College by the Sea, needed to be transformed dramatically into something more important. In other words, a school with it already had a fairly strong professional school presence, but it also needed to become a graduate school and research center. And he very, very much was able to effectuate that for Dalhousie. So he really transformed the organization. And because he was as charming as he was, some people said he could charm the birds out of the trees. One of the other people he was able to charm was Dorothy Killam. That's a name you've probably heard if you've lived in Halifax for any period of time. Within 2 years of him becoming the president, he managed to get Dorothy Killam to bequeath $30 million to Dalhousie. Okay? How much do you think that is in today's dollars? That's $290 million. Can you imagine that? So Henry Hicks was an amazing person in many, many ways, and he was one of the first people to recognize that at Dalhousie, at that time, it was extremely strong in the sciences, and he spent a lot of money in building the Tupper building and improving on the medical school, but he wanted to make sure that the law school, which he knew was also one of the crown jewels of Dalhousie, would start to interact more with the other departments and faculties within the university. And he did that. I think something that he did very effectively was he managed to recruit our St. John MacDonald, or Ron, as we called him. He had been the dean at the University of Toronto Law School, and he brought him back to his alma mater. Ron had done his LLB here at Dal, and he brought with him Doug Johnston. Those of you, I see a number of people in the audience who knew Doug well, and some of whom worked under Doug. He was just an incredible academic, incredible visionary, and exactly the right person to come here at that time. So Henry Hicks met with Doug specifically and told him that he wanted Doug to help to create a marine and environmental law program and studies that were going to be of a more cross-disciplinary nature. And Doug was a perfect person for that. Why? Well, because there was no idea that Doug ever met that he didn't like. That was a wonderful attribute that he had. He could find connections between almost anything. And then by training, Doug had done, he's originally from Scotland in Dundee, but he did his doctorate in law on the topic of the international law of fisheries under Myers McDougall and Harold Laswell. Now, I'm not sure if anybody cares who those old codgers are, but trust me, back in the day, they were incredibly influential people. Myers McDougall started the whole concept of policy sciences and using policy to help develop the law and determine where the law should go. So he very, very much encouraged a multidisciplinary approach. And when Doug wrote his seminal work on the international law of fisheries as his doctoral dissertation at Yale, he very much focused on what needed to be done in all the different sectors to ensure an appropriate framework. So that's something that he brought with him. Another thing that Ron did, Ron was maybe not the best organized person in the world, but God, was he a really good networker. Ron knew everybody. He was the person, there had been an international law group that was kind of run by the Canadian branch of the IBA, the Canadian Bar Association, but it was stodgy and not going anywhere. Ron decided to start something new and vigorous, the Canadian Counsel on International Law. So he knew everybody in the sector. And then he and Doug got together with a third colleague from the University of Toronto, Jerry Morris, another person well known in international law, and they created a seminal book that they started in 1972 called Canadian Perspectives on International Law. It had something like 40 chapters in it, each from mostly Canadians, writing about how Canada should look at international law a little bit differently. Doug's chapter happened to be on international environmental law. Again, very appropriate. We've already talked that he knew the fisheries side. He was now one of the leading scholars on the environmental side. So that was starting to kind of put the pieces together. And very importantly, as authors in that were not just other academics from all across Canada, but also Alan Gottlieb, who many of you know became a very senior person within external affairs and our longtime ambassador to the United States. Too bad he's not around to manage what's going on in the States these days. Nobody could have done it any better than Alan Gottlieb, and he was a scholar in his own right on Arctic sovereignty, the Gulf of Maine, the Seabed Authority, etc. Other contributors were Len Legault and J. Allen Beasley, who were two of Canada's leading negotiators at the Law of the Sea Conference. So when Doug and Edgar arrived, they had this huge network of people that they could call upon, and all of those people already knew them as some of the leading scholars and networkers in Canada in this area. So that brought a lot of focus from those fields to Dalhousie. And so Ted and I come bumbling in 1977, and we're able to take advantage of that. So during that period, just as Ron and Doug arrived in 1972, and as I mentioned, Henry Hicks had already asked Doug to start to put into focus sort of a multidisciplinary marine and environmental law program. There was another character, Edgar Golds, who some of you I apparently saw remotely earlier today. Edgar had been a sea captain for many years, came into town, fell in love with a local girl, and actually he's going to be here in town on the 26th, because shortly after that is going to be his 60th wedding anniversary. And they had a double wedding with Judy's sister and her husband, and so they're going to celebrate the double wedding 60 years later. In any event, Edgar falling for Judy was wonderful for us. He became a landlubber, did a law degree, and lo and behold, but again, serendipity comes in, and what happens? The tanker Arrow, during a gale, manages to go and crumple on Cerberus Rock in Chedabucto Bay. Okay? spilling all sorts of oil, the worst oil spill in Canadian history at that time. A royal commission is put together, and Edgar, who is still an undergraduate law student, is then appointed because everybody knew not only had he been at sea, but at one point he had also been a supertanker captain. So he knew a little bit something about what happens on board. And so Edgar was then put on that commission as the clerk, and he's doing this still as an undergrad, and then he graduates in '72, just as Ron and Doug are arriving in town. So what happens, then Doug immediately then realizes that Edgar would be a great person to help him in figuring out how to map out the marine environmental law program, which Edgar does. Edgar then gets funded to go and start his doctoral studies at the University of Wales. And then he comes back, and lo and behold, he is enticed by Ron to join the faculty, and now you've got a lot of key persons. But wait, there's still a couple more missing. One is, we kind of need a little bit of strength on the environmental side, and who do we bring in? Art Hansen, who had done a lot of work overseas in international development on a sustainable level, and he then becomes the director of the Institute for Resource and Environmental Studies. And then who else? Graham Day, or Graham as we knew him then, Sir Graham now. He was enticed to come back from England after organizing all of the British shipyards into British shipbuilders, ran into a bit of a disagreement with the then Prime Minister Callaghan. He came over and started the Canadian Marine Transportation Center. So now we have not only people in law that are wide thinking, we also bring in somebody with a huge amount of on-the-ground international development experience in Art Hansen, and somebody who has a huge amount of international business experience in the form of Graham Day. And those people then coalesced to put together a proposal to shirk the Social Sciences and Humanities Research Council, which again, Henry Hicks worked very hard. He knew the people on Canada Council very well because he had been a member of the Canada Council earlier. Never hurts to have somebody who's in the know. And they were able to get $1 million in funding at that time, which was the largest grant ever given to any legal project in Canada. To give you a sense of how much $1 million was at that time, my starting salary at Dell in 1981 was $35,000. So it was the equivalent of 43 beginning first-year professors in terms of how much was given. So it was a huge amount of money, and there was all sorts of activity taking place. We were getting involved in all sorts of different areas, and to the point within a couple of years, we actually hosted the Law of the Sea Institute's annual conference. So in the international law of the sea world, that was kind of the most important conference to attend annually, and we hosted it in 1982. So we had come from a smattering of people to growing very quickly. And once we had the funding, we were able to attract other people, okay? Some of you may have heard of somebody called Phil Saunders. Well, Phil happened to be a student in my first year contracts class. I realized he was really smart, and he had a great sense of humor, which was going to fit in with our group. And so he was immediately hired as a summer student research assistant. Peter Underwood, who some of you may know, he at that time was a year ahead of Phil, and he was had already had a master's in oceanography, and he was had also worked as a fisheries observer on board foreign trawlers, so knew a lot about the basics of how things work on board ships. It was a tremendous time. At the CMTC, the very bright young business professor, Mary Brooks, who is here with us today, was also there and joined in and started to get involved in that program and helped Graham develop that program and to build it out. So when you look at what happened, we were then able to attract not only undergrads, but then also graduate students. Another guy, Dave Vanderswag. Dave happened to be on an island off the coast of Nova Scotia. He was a back-to-the-lander. He built his own cabin without a chainsaw. He did it all by hand, and decided that he had lived the environmental life. Now he was going to learn about how to promote it, and he came in to do a master's in law under Doug. And then Aldo came with Elizabeth Borghese, who had been given a Killam Fellowship to come here to Dalhousie. So that Killam name pops up yet again. And then she brought the International Oceans Institute, which had been in Malta, Aldo's hometown, and yet another important piece of the puzzle comes to Dal. So that planning that occurred was incremental. It took time. People came. But, you know, to be quite frank, when something is built up, eventually it goes through ebbs and flows. And I felt very lucky to be here during the period where it was all going uphill. And so I see my time is up, and so I'll ask Phil if he might have 2 minutes to add in terms of what a student's experience was at that time.
None of it was my fault.
If you know Phil, you know that's not true.
I do just want to speak for a couple of minutes. Those of you who don't know me, I've been associated with the school as a faculty member and for a spell as dean over the last 20, 30 years. But my start at Dal was lucky. It's the only way I can describe it. I applied to Dal. I was a district officer for about 3 years in the middle of the Kalahari Desert in Botswana, which doesn't really prepare you for a career in oceans, except for the big vistas. And I was thinking of applying to law school, and my boss, who was the district commissioner, the next step up in the civil service, was quite angry at the notion that I might not apply, because he grew up in South Africa, and when some of the apartheid laws came in the early days, he, as a court clerk, was barred from having any job that involved using a typewriter. He moved to the old protectorate, the Bechuanaland Protectorate, and eventually became a district commissioner and then a judge without a law degree. And he felt it was an obligation to go to law school if you could. So I did. And the only one that took me, the only one that answered my letters, was Dalhousie. All of the others thought I was a foreign student applying, and I didn't have a valid LSAT because mine was out of date. Brent Cotter, who was the admissions officer,
Now Senator Cotter.
I should put it that way. Let me in anyway. We both arrived here in Halifax in the fall, not knowing what to expect. I was assigned randomly to Norm Letalik's contract section. And this is the student's view begins. Norm offered me a job that began even during the term a bit. And he said, your job initially is to work with Douglas Johnston, which was an incredible break. And what I reflect on looking back is what an astounding atmosphere was created by various people. Hugh Kindred, who I took international law from, Dave Vanderswag, who was senior to me, but as an associate there, Aldo, who came during my time there. Some of the most generous scholars and the most open to ideas and to participation that I've ever seen. Doug Johnson took me as a first-year student, and he said, well, we're going to do a book on, with contributions on maritime boundary making. Now, there are 8 levels to this problem. Later it was 10, then it go back to 8. He approached everything like that, but it always winnowed down to something. And what I didn't expect, I thought, okay, I'm a research assistant, I might be lucky and get a little note in the forward, an acknowledgement. At the end of the project, a couple of years later, apart from putting my name on the chapter that he had written and I had helped, he put my name on the book, which I couldn't believe and was richly undeserved. But that's the way the plays worked. The credit was distributed broadly, the work was distributed fairly, and the atmosphere was open. That continued, and I mean, within my class, we had people who were associated in various ways. Ian Holloway, longtime dean at Calgary.
And Western.
And Western. Hugh Williamson, who is around the place forever, and various people who would come and go. But the students in the undergraduate program in the law school were always given an easy and equal standing in discussions, and you weren't expected to sit in the back and listen. And all of that for me meant that one decision to come here first, and then Norm's decision to offer me a job in first year, changed everything for me from that point on.
Yeah, one of the things that I didn't appreciate was the insane amount of rich mentoring that we got from amazing people. Almost everybody that we're talking about today has the Order of Canada, other than me. And when I went into law practice, trust me, in an environment where people have to account for every 6 minutes of their time in the office, they don't spend a lot of time on mentoring. So I look back enormously fondly. And when I finally rose high enough at BLG that I had some control over how we were training our associates, one of the first things I did was I implemented a mentorship program because I knew how important it was for young people to get good mentoring right from the get-go. And it's inconceivable that ananybody could have had a better mentoring situation than we young people did at that time.
It was astounding. And I just point to the rest of my career basically depended on that decision at the very beginning. I was lucky enough to go from there to the International Center for Ocean Development as one of its first employees, 7, 8 years there, back to Dalhousie. All of that was built on the way that MELP and DOSP in the old days treated its students and made them part of the academic process. The one thing I will add, and Sarah will let me go beyond the time for this, what really encourages me is that's what I see now in retirement when I look at how MELAW and the program are functioning today. I see a similar attitude. I see a broadening into more of the faculty, and looking back, I can't be happier about the prospects for the program. It's not just nice recollections. Thanks.
One of the things I learned from Douglas Johnston and Edgar Gold is to take the long view of history, as it were. And indeed, I'm going to share with you some reflections over a 50-year period, 50 years of MELP, and of course 20 years of MELAW included, and speak a little bit more substantively to the law and how it changed over time, and indeed how that might have shaped perhaps how MELP and MELAW evolved. And my focus, though, will be primarily on the maritime law side, so that means the law of navigation and shipping. But in speaking to the law of navigation and shipping, it's impossible, really, not to refer to some dimensions of the law of the sea, international environmental law, that clearly interfaced with maritime law. And of course, when we talk about maritime law, in Canada, we have to think in terms of both international and Canadian maritime law, because really the two are a continuum. So going back 50 years then, how has maritime law changed over time? And with what consequences? What triggered change? And consider that since the establishment of MELP, we've had over 50 international maritime conventions, the bulk of which are in force. And they were accompanied by some 20 conventions on the law of the sea, environmental conservation, fisheries, and climate law. And these numbers do not account for the many regional regimes, such as the Regional Seas Program that Elizabeth explained to us. And then, over the same period, we had some 20 federal maritime statutes in Canada, and with several more in the environmental and conservation fields of relevance to shipping. And that does not even include statutes of general application having a maritime component such as customs, criminal, and port law. So you see this massive amount of law over a 50-year period. Of course, how did we get here? Well, I think we have to roll back perhaps a little bit earlier and ask ourselves, what is the baseline? What did we have before 1970 until the mid-70s? And certainly, we had a law of the sea, of course, but it was a law of the sea which was the product of the first United Nations Conference on the Law of the Sea, convened in 1958, producing 4 conventions that played a very important role in developing, progressively developing and codifying the law of the sea, but they also left some huge holes. And they were pretty much hostage to technological development and, of course, the politics of international relations. So the law of the sea had some big gaps, but frankly, so did other sectoral areas of international law. With a very basic fisheries law, it was still focused very much on development, because at the end of the Second World War, there was a shortage of food, and when the Food and Agriculture Organizations of the United Nations was set up, it had as its principal focus produce, a legal framework that facilitates food production, basically. So it was focused very much on agriculture and fishing, but really with an emphasis on development. There was no thinking about management conservation at the time. It was all about production. In addition to FAO, we did have the International Labour Organization, which was really established earlier at the Treaty of Versailles, actually, and continued. In fact, the only organization that continued from the League of Nations days. But frankly, its work on seafarers, the protection of seafarers, had as yet to develop. There was a committee of experts on the transportation of dangerous goods established by the United Nations, but it essentially was very focused on an issue area. And much of the maritime law that was developed had actually been developed by the Comité Maritime International, which was an organization established in 1897. It was recommended by the International Law Association, actually, which was the first to be established. And it produced a range of conventions known as the Brussels Conventions, many of which actually entered into force, but primarily focusing on the private maritime law. So essentially, what we had before 1970 was a law and a few organizations that were still in development, at the center of which was the IMO, the International Maritime Organization, created by treaty in 1948, operationalized in 1958, and basically created to focus first on safety standards. Indeed, it was established as a consultative body at first. It was not the regulatory body that we have today. So it was dealing with very few instruments. It had, of course, a version of SOLAS, the International Convention on the Safety of Life at Sea, Convention on Load Lines, and a basic convention on oil pollution from tankers. And therefore, the body of maritime law that existed at the time was fairly limited. And what we have to consider too is that the late 50s into the 60s was a period of extensive decolonization. We had a lot of new states joining the United Nations, and many of these actually aspired to become maritime nations. And they started challenging the traditional maritime states for a share of the global tonnage, hence the emergence of open registers, what were also considered flags of convenience. So basically, states that opened their registers to shipping, so they registered ships without necessarily having a beneficial link to them. So this was interesting because it did pose a problem for the IMO in terms of how the composition of the Maritime Safety Committee was going to take place. And indeed, there was a lot of tension between these traditional maritime powers and, of course, the newly developed independent states. And indeed, that conflict had to be resolved on the basis of an advisory opinion from the International Court of Justice in 1960. Anyway, so we had basically a few organizations with a few conventions in place, and then what was needed was a good major oil spill. And this is what we see in the law, in the development of international maritime law. Sadly, much of the maritime law that we have has really developed in response to casualties or problems. Very little of it has been proactive. And of course, this major spill was the Torrey Canyon in 1967, which caused massive pollution on the coast of Cornwall in the United Kingdom. And indeed, it highlighted all kinds of problematic issues in the law, the extent of jurisdiction of the coastal state. When there is a ship on the high seas that threatens your interest, do you have any jurisdiction? Which at the time the United Kingdom did not. And then there's the question of what do you do once you have a major spill? You need to clean up. Then you have essentially victims that need to be compensated. And there wasn't the law really to support all of that. So indeed, this provided a major opportunity for the IMO to live up to the occasion and grow as a body, basically. And indeed, it did. It responded by the development of the first convention on civil liability for oil pollution damage. And this was eventually supplemented by the establishment of the International Oil Pollution Compensation Fund. There was, of course, also the development of the International Convention, or rather the Convention on Intervention with respect to foreign ships on the high seas posing threats to the coastal states, so-called the Intervention Convention. And indeed, the IMO itself discovered that its structure was insufficient to respond to these challenges. So hence, the legal committee was established, and that became the second committee of the IMO. A few years later, the IMO would establish the Marine Environment Protection Committee because it realized that basically now it had also an environmental mission to perform, and it just didn't have the structure to be able to do that. So safety was accompanied by a legal committee as well as an environment committee. So basically what we had in 1970 was an insufficient maritime law. We had a nascent organization, and there was the need to start a process of legal development and law reform. So we had then the 1970s. So I'm going to now take you through a cruise through the decades to give you a sense of how this volume of law came about and what impact that might have had for us in Canada. So the 1970s are interesting because there was faith in the rule of law, perhaps more than there is today. There was faith in international institutions and as instruments for international cooperation. What Wolfgang Friedman, in his Changing Structure of International Law, described as an international law that was evolving from a law of coexistence to one of international cooperation through international organizations. And this was amply manifested, I think, starting in certainly in the ocean and environmental field in the 1970s. So what we see here is really a major revolution, and indeed a true shift to a law of international cooperation. So arguably the 1970s were the most prolific period of international ocean and maritime lawmaking, at least in my perspective. both from the public and the private law side. And then what we have to remember too, on the public law side, was the convening of the Third United Nations Conference on the Law of the Sea in 1973, conference that lasted until 1981, eventually leading to the adoption of the Law of the Sea Convention in 1982. IMO was not the only body, of course, that was active during this period. There was also the International Labour Organization, the United Nations Conference on Trade and Development. And so therefore you had now different organizations jockeying for position and for influence. Vitally, early in the 1970s, there was the United Nations Conference on the Human Environment, Stockholm. And in a sense, that struck a keynote for regime building at the international level. And Elizabeth explained to us how UNEP was established in that year, and of course, 2 years later, the Regional Seas Program. But that conference produced a declaration of principles that are actually quite important. They helped inspire the legal development at the time, including in the maritime field. So these principles, Stockholm was very important, but we also had a number of major technological developments at the time that heavily influenced the playing field here. We saw the beginning of the age of containerization, which revolutionized shipping. And indeed, we had the introduction of new technologies to facilitate navigation, such as maritime satellites and so on. So the IMO became quickly involved in more active regulation development with the adoption of a series of conventions, including on collision avoidance in 1972, safe containers in 72, a fourth SOLAS convention in 1974, overhauled, and then conventions on maritime satellites and search and rescue. Parallel to this, but also related to it, was the convening of a conference to adopt essentially rules on dumping at sea, the London Convention at the time, eventually supplemented by the London Protocol in 1992. And there was the also initiation of negotiation of the International Convention on the Prevention of Pollution from Ships, MARPOL, perhaps the most important pollution prevention convention. And indeed, this was a successful conference. Convention was adopted in 1973, but there were lots of concerns with it, and it sort of stagnated. Lo and behold, we had another major casualty, which helped move things along. So we had the Amoco Cadiz, this time another supertanker, grounding off the coast of Western Brittany, huge spill, and the international community at the IMO recognized that MARPOL somehow had to be brought into force. And indeed, it was amended before it actually came into force with the Protocol of 1978, and that helped open the door to eventually enable it to come into force in 1983. During this period, the ILO also adopted the important ILO 147, which was the precursor of the Maritime Labour Convention down the road. And indeed, other initiatives at the time involved also the involvement of the International Atomic Energy Agency that worked with the IMO to develop a convention on civil liability for the maritime carriage of nuclear materials. On the private law side, there was actually a fair bit of development. Previously, the carriage of goods by sea law was pretty much dominated by the Hague Rules of 1924, the Hague-Visby Amendments of 1968, and newly independent states basically felt that this law really did not fully reflect their interests. So they lobbied UNCTAD and the United Nations Conference on Trade and Development, indeed took the cue and helped develop and adopt the Hamburg Rules. The hope was to level the playing field. In reality, perhaps it helped fragment the law on the carriage of goods even more. So we ended up with parallel regimes on the carriage of goods. So much for uniformity. Down the road, UNCITRAL, the United Nations Conference on International Trade Law, would take over from UNCTAD to address the issue of fragmented carriage of goods by sea law by developing the Rotterdam Rules. But Again, there was not sufficient take-up, and now we have 3 parallel regimes concerning the carriage of goods by sea. So we haven't really achieved uniformity there. UNCTAD also worked on the development of a code of conduct for liner conferences. Again, another attempt to try to level perhaps the sharing, the benefits of shipping. And it did produce this code with a formula to share cargo. But in the end, of course, perhaps the technology took over, and the way containerization and the business of shipping was conducted was probably to sideline that effort. So the issue of fairer sharing of shipping still remains today. This period, of course, had quite an impact in Canada too. And Norman mentioned the SS Arrow, which essentially rang a bell that we needed some sort of a regime here to address the issue of how to cover the costs of compensation and cleanup. So Canada, of course, bought into the CLC Convention, the civil liability regime at the international level, but there was the vision there to establish a dedicated fund, which today is known by the name of the fund, until recently the Ship Source Oil Pollution Fund, which has created a 3rd level of compensation. And Canada remains, I think, one of only 2 jurisdictions in the world that has also this domestic fund. There are actually several other incidents. We had quite our share of maritime casualties. The sinking of the Irving Whale, oil-laden barge, and eventually it would be resurfaced, and many, many years later, the cargo recovered and then put back into service. It's amazing how resilient barges can be. And then we had the collision between the Air One and the Sun Diamond in Vancouver Harbor, producing a spill. And in 1974, the Golden Robin that produced a Bunker C spill in the Miigwech Marsh in Quebec. Then we had the Kurdistan, another big spill, perhaps not as big as the Cicero, but still spilled 6,000 tons of oil. Still a major spill.
Off Nova Scotia.
Of Nova Scotia. So not too far. Cape Breton, of course, has had its unfair share of these casualties. So this was an interesting period of maritime law development in Canada too. We had essentially the conversion of what used to be the Exchequer Court into the Federal Court with the Federal Court Act in 1971, and we see essentially a modern era in the administration of maritime law in Canada. So let me continue through the 80s and push on. Now we have the adoption of the United Nations Convention on the Law of the Sea, and Elizabeth has shared to us the significance of this convention. And of course, the role of the IMO is the competent international organization for shipping, central regulatory role, but not the only organization concerned with shipping. We still have a role for the ILO, UNCTAD, UNCITRAL, FAO, and UNEP played also a role. We had a long period of stagnation before the Law of the Sea Convention came into force. And indeed, it took some major diplomacy under the guidance of Ambassador Satyananda at the time, who is actually an honorary doctorate recipient from Dalhousie for his work as the ultimate oceans diplomat. He helped secure that compromise that eventually, and he convinced the United States to set aside temporarily its objections and lead to the development and adoption of the Part 11 implementation agreement, and eventually that opened the door for the Law of the Sea Convention to enter into force in 1984. So lots of things happened in the 1980s. In addition to the Law of the Sea Convention coming in, or rather having been adopted, and we had a number of other conventions adopted by the IMO. The IMO actually now developed a 3rd function in addition to maritime safety and environment protection. Now it entered the world of maritime security, following the hijacking of the cruise ship Achille Lauro which was hijacked, and the law concerning piracy was insufficient to address a situation of hijacking when you have essentially a vessel taken over, not for private gain, but for political purposes. And that led indeed to the 1988 adoption of a convention concerning unlawful acts against the safety of navigation. Not all efforts during this period were successful. UNCTAD, for instance, tried to develop in fact adopted a convention on the registration of ships to try to strengthen the beneficial link, but this convention never came into force. UNEP, though, had more success with the development of the Basel Convention on the transboundary movement of hazardous waste, and that's a very important convention today. So basically on the public law side, we had a mixed kind of record. In Canada, the 1980s were important too, because again, we had some casualties that really brought into focus some weaknesses in the law. You may recall, for instance, the loss of the Ocean Ranger, this oil rig, which was lost with all loss of life, some major design issues, safety concerns that happened in 1982. And then in 1985, we had the Polar Sea voyage through the Northwest Passage, a kind of a replica passage to the Manhattan earlier in 1969, which triggered the adoption of the Arctic Waters Pollution Prevention Act. Now the Polar Sea triggered the adoption of baselines in the Arctic for Canada, in a sense, to make it very clear that this was an area that it did consider as internal waters. Also in this period, there was an interesting case law developed by the Supreme Court of Canada, and specifically taking a very federalist vision of what admiralty jurisdiction is in Canada. And I refer here primarily to ITO, the Buenos Aires Maru case, which was a very important case, remains a very important case in terms of defining what is Canadian maritime law and its characteristics as a federal body of law. Then we moved through the 1990s, which I describe as a romantic period of lawmaking. We had grand visions, commitments, groundbreaking principles and norms, in a sense testing and pushing the limits and capacities of the structures of international law. I suppose the first test here was really, interestingly enough, the grounding of the Exxon Valdez in Alaska, because frequently the case, the US would take a unilateral approach to legal development, and with the adoption of the Oil Pollution Act of 1990, it in essence forced the international community to rethink how we should be regulating tankers, and indeed should be requiring double hull requirements for the construction of these ships. It also raised some interesting questions concerning liability and compensation. 1992 was a seminal year because of the United Nations Conference on Environment and Development, the adoption of the principles on environment and development, the adoption of Agenda 21, and indeed the UN Framework Convention on Climate Change, as well as the Convention on Biological Diversity. So, as you see here, these are monumental instruments in essentially international environmental law, which cast a long, long shadow, of course, on maritime law. I should mention, too, as an aside, that some of us were at the United Nations Conference on Environment and Development and helped with the eventual establishment of Oceans Day as an annual day to be celebrated. And David and I were active participants in the Global Forum as part of a delegation that an organization that does no longer exists, the International Center for Ocean Development, organized at the Global Forum. 1992 was also a big year at the regional level with the Ottawa Declaration establishing the Arctic Council. And the Arctic Council has played actually an important role in forcing us to think about Arctic shipping, especially the work of the working groups, Protection of the Arctic Marine Environment, and of course EPPR. And indeed, this organization played a critical role in helping develop a kind of a roadmap for the regulation of polar shipping, in particular through the Arctic Marine Shipping Assessment Report, in which MELP played a rather important role by contributing the chapter on the governance of shipping. And moving on, then, we've heard from Elizabeth the other important developments in the law of the sea, such as the other implementing agreements. You mentioned the Threatening Stocks Agreement and so on. But there was other work at the IMO going on here, conventions on oil preparedness and response cooperation, the adoption of standards also for the training certification of seafarers, work that had been done, and the convention adopted in 1978 now was replicated by a sister convention with respect to fishing vessel personnel. FAO, on its part, also adopted a compliance agreement to enhance flag state to exercise control over their ships with respect to conservation and management measures. On the private law side, again, UNCITRAL continued to play an important role with respect to the development of the liability of terminal operators, although that convention not quite entering into force. But UNCTAD had more success in the development of a convention concerning liens and mortgages and the arrest of ships. The IMO, on the other hand, was not successful with the convention on the concerning hazardous and noxious substances. It's a convention that is still not in force today. And in Canada, the 1990s were characterized by, again, a few interesting maritime incidents. In particular, the arrest of the Estay, remember the Spanish fishing vessel that was essentially fishing on the high seas, but in violation of NAFO conservation requirements. And Canada took the unilateral initiative to arrest this vessel on the high seas, which was an interesting situation because, in essence, our actions were not easily justifiable at international law, if at all. But of course, Canada had taken the steps to ensure that that the International Court of Justice jurisdiction with respect to such disputes was withdrawn. So when Spain took Canada to the International Court of Justice, the International Court of Justice found it had no jurisdiction. So Canada got away with it. But it was important because that incident did play an important role in the future development of the Threatening Stocks Agreement. But domestically, we had quite a few other important developments. The public review panel on tanker safety, for instance, provided, in a sense, future directions for further developing the law with respect to oil pollution response and even with respect to compensation and so on. The 1990s were also important because we had the adoption of the Canada Marine Act, a reorganization essentially of ports in the country, and in 1999 the adoption of the Canadian Environment Protection Act, which, among other, for the maritime field, had implications because it embraced, of course, the international law here with respect to dumping. We also, in 1993, had the adoption of the Marine Insurance Act and the Carriage of Goods by Sea Act. The Carriage of Goods by Sea Act now, at least, has been overtaken by the Marine Liability Act. This was also a time when admiralty jurisdiction continued to develop, in particularly with the seminal case of Ordnance State versus Grail, which highlighted some major gaps in the law concerning maritime negligence and the need to not only incrementally develop the common law, but also calling upon the legislator to further develop the law in this respect. And that played an important role in paving the way to the Marine Liability Act. And then since 2000 until today, we're looking at a post-romantic to a realist period. I would say it's a period of grand ideas still in legal development, but we see a counter trend here back to a realist school in international relations with hegemons, I think, treating international regimes as instruments for primarily nationalists rather than community purposes. We see also the law being tested here in terms of its ability to cover threats faced by coastal states when you have, for instance, vessels in distress off your coast, the traditional custom of providing refuge. Well, coastal states had to take into consideration also what might be the impact if you have a ship that breaks up close to the coast. So unfortunately, the law here could not be developed further, but instead the IMO stepped in, produced guidelines, and they appear to be serving the role of soft law. The IMO, though, continued to address the issue of threats to the marine environment from shipping by adopting conventions on anti-fouling, ballast water management, as well as guidelines to address particularly sensitive sea areas of the marine environment and how we ought to protect these. At the same time, the trend to continue to designate special areas to restrict discharges, waste discharges from ships continued. This is also a period, especially the contemporary period, where we see the development of standards for polar shipping, their adoptions, they're being embraced basically by all Arctic states, and major efforts at the decarbonization of shipping. Very controversial, very divisive, perhaps, efforts in many ways. We still have a long way, even though we had with Marine Environment Protection Committee, the last session, 83, a document that has been put forward. Some of the proposals there have been adopted only on the basis of a majority vote. And the IMO has always attempted to achieve consensus. Now, we'll see whether actually the full MEPC 84 next year will adopt this whole package. It's a package that will involve, at least on the table, is the equivalent perhaps of carbon charges. Some would want to characterize those as a carbon levy in addition to technical measures and rethinking the system of credits for green ships. This is also a period where we see the rethinking of regulation to take into consideration the introduction of autonomy in shipping. At this point, in Canada, we see a range of incidents, again, forcing us to think about the limitations of maritime law. In 2001, we had the incident of the MV Kitano fire on board a ship, would not be allowed into Halifax Harbor before it extinguished the ship, and that helped clarify perhaps our approach to places of refuge. We had a series of spills off the coast of Newfoundland to the point where Newfoundland basically was very vocal, and in the end, we had important amendments to the Migratory Birds Convention Act, where we have the introduction of indictable offenses. And in a sense, the amendments have been criticized for potentially criminalizing seafarers, but actually potentially also boards of directors. More maritime incidents, in particular for Cape Breton again, the MV Minor. We have a bulk carrier which was being towed and grounds on Scattery Island, and this was also a nature reserve. Nova Scotia had hoped that the federal government would pay for the salvage. No, the federal government did not pay for the salvage, and Nova Scotia ended up footing in a $12 million bill. But this is also an interesting period because it highlighted the problems of abandoned ships in ports and waters right around Canada. And indeed, the rethinking of how we should be looking at wrecked and abandoned vessels, leading indeed to a new piece of legislation reorganizing the law of wreck and salvage in Canada with so-called the WAVA statute. And so major law reform, perhaps the most notable here, is the total overhaul of the Canada Shipping Act 2001. which, as Ted McDormand once wrote in his thesis, was still based on 19th century British merchant shipping legislation, which was odd because that legislation was the legislation of an empire thinking about shipping, global shipping, and mobility. Whereas we in Canada were primarily a shipper nation rather than a ship-owning nation. But nonetheless, somehow the Canada Shipping Act moved along. But thanks to the efforts, in particular, of Bud Streeter, who helped reorganize the redrafting of the Canada Shipping Act, reorganization of the entire system of regulations. We had over 100 sets of regulations, brought down to 33 sets of regulations, and so on. And the Marine Liability Act I've mentioned, Marine Liability Act actually is worth a few more words because it helped reorganize the legislation which was implementing a number of international conventions, such as the Convention on Limitation of Liability for Maritime Claims, the Athens Convention for the carriage of passengers and their luggage, reaffirmation that we're sticking to the good old Hague Visby rules, 1968, because our trading partners are still essentially operating under those rules, and then implementing the CLC IOPCF Convention and the Bunker Oil Convention. With respect to the jurisdiction of the federal court, basically here we see an interesting term, because now we see here, in a sense in maritime law, one can say that whenever there is a constitutional sneeze, maritime law tends to catch the cold. And what we had here was the development now of cooperative federalism as a doctrine, and this raised some interesting issues and potential problems for the uniformity of Canadian maritime law. And in particular here, I'm referring to the decision of the Garnier versus Wärtsilä, which essentially the judgment of the Supreme Court favored the application of provincial law over federal law. Federal law here would have been, of course, primarily the maritime common law, with respect to the law of necessaries, which essentially was quintessentially a maritime law dimension governed really by maritime contracts. So we have a situation now where, although necessaries is a typical maritime law transaction, potentially is governed by provincial law, or could be governed by provincial law, which of course raises another question as to what does that do to uniformity. But anyway, that is how we've had this development over the years, and thinking now what's beyond the horizon, as it were, and what does it mean for us in MELP? Well, climate change and decarbonization are going to be very big for us, I think, for curriculum development and certainly for research. We'll have to be thinking in terms of what will Canada's position be with decarbonization and the potential levy on board ships. What will this law mean, for instance, for our rethinking of what is seaworthiness in shipping? Especially when we're going to have different sets of fuels available, and we will have different energy efficiency requirements. So we'll have to ask ourselves for courage, but not just for courage, but right across, what does this mean for seaworthiness? Indeed, area-based management. I think we're going to see a lot more area-based management taking place, we, for instance, have an initiative for the designation of low-impact corridors in the Arctic. Transport Canada has, with the support of the Olution, or rather with the OPP federal program of funding, the establishment of proactive vessel management. And what these mean really is basically designation more and more of areas with certain restrictions for navigation, or areas such as, for instance, the oil tanker moratorium of the West Coast, or areas where we have corridors designated and then we have a system of routing measures, which is likely the case in the Arctic. So this would be interesting to observe. Then we have automation is going to be very big. We're going to potentially in the future have ships that are remotely controlled from shore. And then perhaps even ships that will, for part of their voyage, be operating autonomously. And what does that mean for the regulation of shipping when you have a remote control center, let's say hypothetically based in Bermuda for a ship which is navigating from, let's say, Antwerp to Halifax? What does it mean for the flex state to be exercising effective jurisdiction and control? But what does it mean also for a port authority, and indeed port state inspection, to have vessels that are operated remotely from another jurisdiction? So quite a few for us, quite a lot there for us to chew on. We're going to have a digital transformation of maritime law and practice, I think. Last week at the CMI, there was a very active discussion of where electronic bills of lading are going, and especially the increasing use of blockchain. And then I would argue, too, that the current geopolitical change we see and the threats to us as a potential 51st state could potentially raise the importance of maritime law. Why? Because we have a government now that is committed to diversifying shipping. Where is the diversification going to take place? Well, 80% of our trade is with the US, it's mostly road and rail. The 20% is mostly European and Asia-Pacific rim, which means that's shipping, that's seaborne trade. So if we're going to be able to diversify the economy, it's going to be more seaborne trade. More seaborne trade means more work for maritime lawyers, there'll be more cargo claims, et cetera, et cetera. So we might have to ask ourselves, could we possibly be anticipating here more interest in maritime law? I would argue potentially yes. And I had quite a few other things, but I realize I've gone way overboard and I should stop there. Thank you very much.
One of the challenges with this workshop, of course, is having so much knowledge in the room and an eagerness to share it, but also an eagerness to learn it. And so with great appreciation, I thank you, Aldo, and I also thank you, Norm, for sharing those reflections earlier.